Hey everybody, welcome to Thursday evening. It's here on the Consumer Warrior YouTube channel. I'd like to welcome all those who are joining with us live and all those who watch this later on. There's most of the people have the opportunity to watch this later on. But every Thursday night, I like to do these question and answer sessions where we discuss different topics on how to deal with debt collection lawsuits, bankruptcy, wage garnishments, bank levies, all that kind of stuff. So my normal spiel, my normal disclaimer that I give every week is that the information that we're discussing here is just that. It's information. It's not legal advice. If you need legal advice, I highly recommend you contact an attorney wherever you're located. A great place to find an attorney, if you're not in Arizona, if you're in Arizona, obviously, you're going to contact my office. But if you are not in Arizona, I'd recommend a good place to look for an attorney who does this kind of stuff because it's kind of hard. There's not a lot of us. Is through the National Association of Consumer Advocates, NACA. NACA happens to be the acronym that about 1,000 different organizations use. But if you go to Consumer Advocates, it's a plural, consumeradvocates.org. That's their website. I don't have any affiliation. I'm not even a member of that organization. But they have a nice little directory there where you can look for attorneys in your state that do what I do, which is help people who are being sued by debt collectors. So, and participating in the video doesn't create any type of attorney-client relationship. I can't do follow-up questions, anything like that, but I'm happy to do what I can here. I can provide just general information about this process. And so usually how we play this out is if there's questions that you have about anything debt-related, we're talking credit reports, bankruptcy, debt collection lawsuits, go ahead and put them in the chat stream there, and we will I'll put them up on the screen, like with Muriel here, who's always here bright and early. Thank you for being here and supporting the channel. I'll put them up just like that, and we'll read the question, and I'll try to give you the best answer I can based upon the information. Granted, I don't know all the laws in every state. I don't have all the background information, but I'll try to give you some just general information and maybe some resources that can help you as you're trying to deal with this. So, all right, let's go with... I'll jump right into a question here with Jesse Lopez. Usually I start with a question that I get from the comments, but we'll start right here directly with Jesse. What evidence can I send to creditors to prove that I'm judgment proof? This is a great question, and I actually just had this conversation with someone who set up a consultation with my office about going over kind of what it means to be judgment proof and kind of pros and cons about dealing with things by not dealing with them, if that makes sense. I did a video once saying, that there are times when you're sued by a debt collector where you have the option of doing nothing. It's rare, but if you're judgment proof, that really means that creditors, even if they get a judgment against you, even if they have their best day and they get this judgment, which they intend to garnish your wages or levy your bank accounts, or they're going to go after property or assets. If the type of income you have is exempt, meaning it can't be touched by creditors, and if you either don't have assets or the assets you have are exempt, then you are what we consider judgment proof, meaning even with the judgment, there's nothing they can do to try to take things from you. Examples of exempt income are like Social Security, most VA disability, those types of things. They can't take that income. By statute, it's exempt. Under federal law, they're not going to be able to garnish your Social Security to pay off their stupid credit card. They're not going to be able to do that. Assets that are exempt, most states have like a homestead exemption that protects up to a certain amount of equity, cars, retirement accounts, those types of things. That's very state specific when it comes to assets. The exemptions are different in each state. And so I have a video, I'll have to find a link for it and put it in there, where I outline kind of where you could look for the exemptions in your state. But Google Scholar is a great place to go, or the Cornell, the Legal Information Institute, it's Cornell Law School. You can Google what the exemptions are in your state, or just Google them, period. They should come up pretty quickly. And you can see which assets are protected. So if you're judgment proof, they can't really take anything from you. And if they have a judgment, you may be thinking, who cares? The only downside to doing nothing, if they have a judgment, while it means that in the end, they're not going to be able to take anything from you, it doesn't mean that they can't continue to try. And so you may get hit with a bank levy, or they may try to sell some asset, or try to execute on some asset. And then you have to raise the defense of, hey, this is Social Security, you can't take it. So you'll win in the end, but it doesn't mean that they still aren't going to be annoying, because most states are like Arizona. Like Arizona right now, a civil judgment is good for 10 years, and then it can be renewed every 10 years for the rest of your life. So long time. And you might be dealing with it. So that's the one little caveat to the do nothing strategy, is that it may be better to deal with it just to get them out of your hair once and for all. So, alrighty. Let's see if we have some other questions here. Are you familiar with Capital Management Services? Started getting their call from Phoenix number, but they are from New York. I don't know. I don't know them specifically. What you're seeing there with the numbers, debt collectors will do what's called call spoofing, where they'll make it look like they're calling from somewhere different, or there's somebody different on your caller ID, the area code showing up even though they're calling from some different state. We'll often see that. So, all right, Alex, always here. Appreciate you, man. Appreciate you, Dan and Yuma. Can I please explain the account stated position that original creditors take? Great question. That's advanced level stuff here. We're talking about account stated. When a debt collector, debt buyer, creditor, whoever it is, when they sue you on a credit card in particular, they often in their complaint will many times have two claims or two causes of action. One is breach of contract, just your standard saying, hey, there was an agreement between the parties, and there's a written agreement or an oral agreement and it was breached. And so, we win kind of thing. The problem with breach of contract for these creditors is that often they don't have the original contract. Most credit cards are signed up online nowadays. And even before that, they'd have the original contract that you signed, or the little postcard thing that you filled out and sent back in. They don't have it anymore. And so if they don't have the original contract, they were in this tough spot where how do they actually prove that there was a contract to be able to show that you breached it? And the answer is they couldn't. And so their fallback position was what's called an account stated. An account stated legal theory is the law provides where essentially the law can assume that there was a contract between two parties based upon their behavior, based upon the fact that, and the way that credit card companies do this is they like to disclose a bunch of monthly statements. And if they can show that there were charges and then payments and then charges and then payments and charges and payments, for a several year period, the court can say, okay, there's a course of dealing between the parties. And because of that, we believe that here's what the terms of the contract were. They are whatever was on the monthly statement. That's the interest rate. And essentially they infer a contract based on this account stated position. So let me tell you a good way around that. The accounts, most debt buyers, particularly if you're usually, this is debt buyer specific, this is Midland portfolio, that kind of thing. When they file a lawsuit, they usually don't have a lot of what they call media. The media is monthly statements, documents, that kind of stuff. And so often they will include a charge-off statement, which is the last statement that the credit card issued. And it often, all it does is it shows is they zeroed it out. It'll show a final balance, but it doesn't provide a whole lot of information. It doesn't show any payments, doesn't show any purchases. And then sometimes they'll have like a couple other statements from earlier on in the life of the credit card. The problem with that and how you can defeat an account stated position is basically you're saying there's no course of dealing. If they only provide 3 monthly statements and not one of them shows a charge, or if not one of them shows a payment, then there's nothing to show your assent to those terms. And so I know that kind of gets into the weeds of it a bit, but that's a good way to defeat that, because in order for an account stated theory to be successful, they've got to show a pretty significant course of dealing between the parties as far as payments and purchases. And if they just happen to put 2 statements out there that don't show any payments and any purchases, they're not going to be able to win an account stated position. So good question, Alex. Appreciate that. All right, let's go to Adam here. Does Arizona use the federal standard for summary judgment? Well, it depends on, I guess, which court you're in. If you're in federal court, they're going to use the federal standard. In Arizona, in state court, like Superior Court, Justice Court, they're going to follow Arizona case law, state case law. And It's pretty similar. I mean, the rules, Rule 56 under the Arizona Rules of Civil Procedure and Rule 56 under the federal rules of civil procedure deal with summary judgment. And so the standard, though, in Arizona, there's a case called Orm School, which is kind of our standard, which really articulates what the standard is for granting it. And the standard for summary judgment, and just to back up a bit, this is where most debt buyers and debt collectors try to win against self-represented people. Is they'll file their complaint, they'll serve you, you file your answer, they'll file like an initial disclosure, and then they'll hit you with a motion for summary judgment because they know it's complicated. They know it's not something, if you haven't dealt with it before, for non-lawyers, it can be difficult to manage or respond to effectively. And so people either don't respond to it, or they respond to it kind of like they did the answer, where they just admit or deny, and that's not enough. Summary judgment basically says the standard is the court should grant summary judgment if there are no material facts that are in dispute, and really it's just a matter of law. So basically, this is where the parties agree on all the facts, and it's really just saying, hey, judge, we agree on everything here. Just tell us who wins. Apply the law to this situation. Tell us who wins. You can dispute that because they shouldn't grant it because there are facts that are in dispute, particularly with the debt buyer. You may debate or dispute that they've shown that they're the owner of it. You may dispute how they calculated the total amount owed, or they haven't shown that. And so those are the kind of things you have to bring up in a motion for summary judgment. I have an online tutorial where we do a huge deep dive into it, because summary judgment is probably one of the most difficult things for people to overcome when they get hit with that. So good question, though, and I appreciate you bringing that up. All right, let's see here. A couple more questions. How long is the average time to wait for court to respond to a motion to dismiss in Arizona, South Mountain Justice Court? Well, to answer your question, they're kind of they rule the world. The judge rules the world, and we're just all here working for them, kind of thing. So I can tell you. So you file your motion. The other side has. I hesitate to even bring this up. This is very Arizona specific, but other states are similar, and I bring it up just to show you that it's just crazy how complicated they make these things. In Arizona, you file a motion. They have 10 days to respond to it, but it's 10 business days plus 5 mailing days, but that's just 5 straight calendar days. And the rules say anything over 11 days, you actually count weekends and holidays and that thing. But if it's under 11, it's only weekdays, except for the 5 mailing days on top of it. So roughly it's 15 days. They have a time to respond to it. Then you have a time of 5 days plus 5 mailing days to reply to it. And then the court, once it's fully briefed, then the court should rule on it. If they don't respond within the 10, 15-day window, I've seen some courts, they rule on things really quick. Most of their clerks will kind of pile these things up and say, okay, they'll give them to the judge right when the deadline expires. Most of the courts here in Arizona, they say that the judges should respond within 45 days from a time that a matter is fully briefed. So that's kind of what you're looking at. But at the end of the day, I can tell you, I've had federal judges sit on things for so long, you pull your hair out, especially as an attorney, because my clients are looking at me like I'm doing something wrong. I'm like, I don't know why they won't do it. And there's not too nice of a way to make them do it. Let me give you one nice little way to make them do it. If that time has expired for the other side to respond, you can file something called a motion for summary disposition. And all the motion has to say is, I filed my motion on this date, no response has been made. It's respectfully requested that you rule on this. That's kind of a nice way of doing it. So I don't know if that's very helpful, but it's their world. We just all work in it. So Marcos, thank you as always, each and every week here supporting the channel. I sincerely appreciate that. So all right, let's look at this one here. Chase credit card refused to put me on a repayment plan simply because I'm currently unemployed. Should I just negotiate a payment to the collection agency in which my account goes to charge off? Well, I mean, the problem that you're dealing with, I guess, if they're not willing to do anything, they're kind of making that decision for you in essence. If they're not willing to, I don't know if it's a, hey, pay us the whole thing, or don't pay us anything, which I don't understand. I've often said logic doesn't govern these situations. Company policy does. And somewhere along the line, somebody at Chase said, here's what our policy is. And it doesn't matter if it doesn't make sense, because you would think you're offering them money, they're going to take it. They don't. So you may just have to wait until the debt's charged off, picked up by a debt collector, something like that. You may get a better deal anyway. The problem is your credit's going to take a kind of a beating along the way, but that may be all that you're left with being able to do there. So, all right, let's look at this one by my man John. Currently being sued by Noonan and Noonan. Writing my response letter. Not sure what to expect once the letter is received. What's your thoughts to settle? Total amount owed is $3,200. So once you file the answer, in most jurisdictions, in most states, it's going to put it into a disclosure or a discovery period where the parties have to disclose information about the case, witnesses, documents. It varies from state to state as far as exactly what has to be disclosed, but essentially you've got to show your cards. There's none of this Perry Mason showing up with, this secret document that's going to win the case. Everything's got to be disclosed ahead of time. It also goes into a discovery period where they can send written requests for information from you and vice versa. With cases that are under $5,000, depending on whether it's an original creditor or a debt collector or a debt buyer case, you're probably going to be able to settle that for about $1,000, maybe even a little bit less. Original creditor, probably going to be $2,000 to $2,500. If you're paying in a lump sum, that's generally what you're looking at. You meant Nathan and Nathan. Got it. We'll put that up there. Got to get that right. Okay. All right. Let's talk about this. So mediation meeting with the courts from an LBNB lawsuit on the 7th. What should I do? I have no idea what to expect. This is a good question. So mediation is the process of basically trying to reach a settlement or an agreement in a more formalized setting. And so in most jurisdictions, what they'll do with that is they will appoint a mediator. The mediator is not going to be the judge that would hear your case at trial. Sometimes it's another judge. Sometimes there are other attorneys. Here locally in Arizona, they use, I don't know if they're volunteers, but sometimes they're law students. Sometimes there are other trained mediators. There's a lot of retired people that do it here. I don't know why, but they do it. It's a service to the community. I should appreciate that more. It just doesn't seem super fun. But they're trained to try to help to resolve the problem. So mediation is not about the facts and the law. I mean, that's always in the background of the whole thing, but really it's where they bring you in. They'll usually tell you something initially, and then often they'll put you in different rooms, and then the mediator will go back and forth trying to see if there's some middle ground that can be reached. And if there's not, that's great. But mediation is a decent time to try to settle. A lot of times, debt collectors and debt buyers, they'll take better deals just to get the case done at that point. So mediation is not something where you're going to have to do some big legal presentation or anything like that. Usually the mediator, they may require some information up front from you, like a brief, just to know what the case is about. But then it's usually just them going back and forth. So what I would do to prepare for mediation is try to determine, is there an amount you would be willing to pay to make this thing just go away completely, whether it's a lump sum or whether it's a monthly payment. That way ahead of time kind of what the deal is. You're not going to have to pay it when you get there or anything like that, or if you come to agreement. Usually there's something drafted up and you pay it within 30 days or whatever the agreement is. But that's generally what you're going to get from a mediation. So, all righty. Let's talk about what Adam has. How's COVID affected my practice? COVID, my day-to-day has not really changed that much. I guess fortunately or unfortunately, I sit in a room by myself most of the day. So as far as, the whole COVID thing, the work situation, but as far as the types of cases, it was interesting. I read, there's an article in the Wall Street Journal talking about, it wasn't Encore. It was the parent company of Unifund. I'm blanking on their name right now. Unifund's big debt buyer, and maybe in Resurgent Capital. anyways, one of the big debt buyers, and they were talking about, hey, here's this huge worldwide pandemic in 2020 that's come out. Surely this has been a bad year for the debt collectors as well. And in fact, the debt collectors, they pushed the pedal down. They actually filed more lawsuits and went after more people in 2020 than ever before, which is really this kind of perverse thing of people. You're thinking, gosh, people are going through all these hard times, and they're actually increasing their collections, not decreasing them. Here's the thing: 2020 was the lowest year for bankruptcy filings in the last like 15 years. And I think, and it's supported by a lot of the research and reading I have done, there was more cash, and there still is more cash floating around for people to use to settle debts than there has been in years. Couple reasons. One, the stimulus checks. People are getting, there's been 3 of them now, and now they're monthly. Particularly people who have kids, and if you have large families, I mean, they can be thousands of dollars a month that are coming in to supplement income. Also, with the eviction moratoriums that are out there, a lot of people haven't had rent expense. And so, whether you agree, disagree with all that kind of stuff, there was just more cash. And the debt collectors knew that. And so they were, the vultures they are, coming in and trying to try to get some of that cash. So that's how has it impacted my practice? We haven't done as many bankruptcies in 2020 and even 2021. We're doing a lot more debt settlement and debt defense stuff, just because there's so many more lawsuits. I am starting to see the bankruptcies start to tick up a bit. And I think that's largely because a lot of the eviction moratoriums, some of the foreclosure moratoriums, as well as some of the credit card issues in that, it's kind of all coming to a head right now. So, all right, let's see. Margaret has a credit, got a judgment against me, and is garnishing my wages. I'm going to pay them. Any suggestions on that process? Once you get hit with a wage garnishment, settlement is more difficult. I always say, particularly like with original creditor lawsuits and even debt buyer lawsuits, if the goal is to settle, often it's positioning your case or your situation so that you have as much leverage as possible to be able to come in and get a low settlement. Because if garnishment's entered, judgment's entered, they're garnishing your wages. In Arizona, they can take up to 25% of every paycheck. And if you come to them with a settlement proposal, they can tell you to pound sand and just keep collecting your paycheck every 2 weeks. So if that's the case, then I would say that, settlement is still possible, but you're going to have to come in with a lump sum, a pretty decent sized lump sum to make them stop it. Otherwise, another option is bankruptcy. Chapter 7 bankruptcy, as soon as you file it with the court, they stop all collections. They have no choice. The garnishment stops, phone calls, letters, everything stops. And that may be the way to go. So, that's a tough spot once the garnishment stops. That's why we want to try to avoid that garnishment if at all possible. So, all right, that's going to have to do it for tonight. But hey, I appreciate everybody checking in. Appreciate all the questions and the support of the channel. Again, I have the tutorials. I listed them at the top of over there in the notes. Those are some good kind of deep dive self-help type stuff. Check those out. If you have other questions, I have over 200 videos on the channel. I'm sure I've addressed almost every question imaginable at one point or another. Check those out. Those are a good resource as well. I appreciate y'all checking in tonight. I will